Good morning. Welcome to the Kreston Reeves Planning for Your Future webinar for accumulators. My name's Sarah Manouch and I'll be chairing the first of our webinars. There's no doubt that this year has been tough and challenging for all of us. It has meant that we have had to focus on what's most important to us, our health and our loved ones. Many of us have had to consider our personal or our family's financial security and know that it is vitally important that we have a plan. One that enables us to fulfil what we want to do now and one that can accommodate turbulent times. With the help of my colleagues, financial planner Kim Williams and partner and head of tax Daniel Grange, this webinar is aimed at encouraging you to reflect on your personal financial circumstances and to create a simple personal finance action list. Now, for illustrative purposes throughout the webinar, we'll be using a fictional but a fairly typical case study. I think you should have a slide on your screen now which sets out that case study, but I'll run through it briefly now. So we have John, he's aged 40 and his wife Fiona is 38. They have two young children, Josh, aged 5 and Amy, 1. John owns his own company and Fiona has a successful career running an employment agency. John has elderly parents. Fiona's brother is in the process of a divorce and John and Fiona want to retire at 65. You'll see us refer to this case study throughout the webinar to help you understand how some of the discussion points can be applied. We'll also be referencing a national survey we recently undertook to better understand individual aspirations and actions taken to plan ahead for their future in what is an uncertain time, so we can provide financial clarity. There will be a question and answer session at the end of the webinar, which gives you the opportunity to submit any questions that you may have. And we'll be joined by the following: partner and head of legal, Phil Lansbury, chartered financial planner, Terry Bergen, chartered financial planner and Society of Later Life advisor, Lee Hayward, and tax director, Joe White. You can ask a question by typing and submitting in the panel on the right of your screen. We'll be circulating a feedback survey after the webinar and would appreciate your time in completing this. We'll also be supplying you with a copy of today's slides. You can of course speak to your usual contact at Kreston Reeves with any specific questions, and you're welcome to contact the presenters directly, including me. Individual contact details can be found on our respective slides. So now I'm going to pass you over to the first presenter, Kim Williams. So Kim, over to you.
Thank you, Sarah. So I'm Kim Williams, financial planner at Kreston Reeves. We help our clients in both accumulating wealth and also distributing it. When selecting and managing investments, we always start with what you are trying to achieve in terms of your financial aims and objectives. Our recent national survey findings suggest that John and Fiona's 3 highest priorities when planning for their future are likely to be having sufficient funds to enjoy their retirement, financial security, and helping family members, so that might be their children, John's elderly parents, or possibly even Fiona's brother. We do this by really getting to know our clients and what's important to them. Our survey tells us that 36% of individuals think they will have just enough funds saved for their retirement. The latest figures published by the ONS suggest that in 2018, the average household expenditure was £30,000. This does not include any mortgage debt, which could be an addition. Whilst all individuals are different, this provides us with some idea of what you should be aiming for. So how could you fund this expenditure? Well, if you take no action, then you're looking at relying on the state pension. 33% of the individuals we surveyed said that they would be relying on the state pension. So under the current rules, this could provide a maximum of £9,000 a year, which is significantly lower than that 30,000 national average figure. You're also reliant on the government not changing the rules. For example, could the state pension be means tested in the future? Or could the state pension ages change again? In John and Fiona's case, the state pension age is 66, but John wants to retire a bit earlier at 65. So there'll be a period of 1 year when they will need to fund their retirement from other assets or sources of income. It's also worth noting that the 9,000 figure is a maximum available and assumes you've made national contributions for the 35 qualifying years. I'd encourage you to check your own state pension record by following the link shown on that slide. So why use pensions as part of your retirement planning? Well, it's apparent that we need to save privately to achieve our goals, otherwise you'll be relying on the state pension at 9,000 a year. Pensions are a good use because you receive tax relief on your contributions, and I'll show you an example of that in a moment. Pensions do not attract capital gains tax, so the money inside the pension grows free from tax. The value on death is free from inheritance tax, so you can pass the value to your family without a 40% tax charge. If you have one, your employer will make a contribution into the scheme on your behalf. You don't have to stop working to take your benefits. The minimum age to access your pensions is 55 at the moment. This is set to increase to age 57 in 2028, but under current rules, you could repay your mortgage at 55 and continue to work. 25% of the value is free from tax, leaving the other 75% subject to income tax at your highest rate. So let's look at an example of John and Fiona's situation. John owns his limited company. He has total taxable income of less than £200,000. This means that his company could make a maximum contribution of £40,000 a year into his private pension. As this is a company pension contribution, it is the company that will receive that corporation tax relief. John will receive some tax relief as he is not extracting money from the business. As it's redirected to his pension instead, it will result in a total tax saving of over £17,000. Moving on to Fiona, she's employed and she's been automatically enrolled into her employer's workplace pension. Based on the level of contributions, this costs Fiona £1,800 a year, but £3,600 is credited into her own personal pension fund once the income tax relief and her employer's contributions are considered. However, HMRC doesn't give these tax breaks away without a catch, so there are upper limits which can be saved into pensions in terms of contributions and overall values. These are known as the annual allowance and the lifetime allowance. This area can be complicated, so I'd always suggest that you speak to a financial advisor regarding your own pension savings before making any decisions, which could result in a tax charge on you personally. So you're saving all this money into a pension fund, but what happens to it then? Your money is invested in stocks and shares, and the level of investment risk you're prepared to take is determined by a number of factors. Like 55% of our survey respondents, John and Fiona initially claimed to be cautious investors, but what does this actually mean? A good financial planner will explain the investment risk to you and what this entails in terms of potential losses and gains over a certain time horizon. It therefore transpires that John and Fiona are prepared to take a higher level of investment risk as they have the timescale to invest over the longer term. Investments should be reviewed regularly, especially in the lead up to your retirement date. Your financial planner will also understand your personal preferences. So one of the key findings from our survey was that there is an increasing importance of ensuring investments are socially and environmentally responsible, with 63% saying it is important or very important to them. Fiona would like to invest into companies of this nature. So we're able to model her portfolio to reflect her views in investing in ESG funds. ESG stands for environmental, social and governance. Being a business owner, John is extremely worried about the effect of COVID-19 or future pandemics on his financial security. Fiona is more worried about job security and stock market volatility. So we're looking at the portfolio structure. A different range of asset classes should be used in an investment portfolio, which provides diversification. When one asset class is falling, another asset class could be rising, depending on the economic and political world. The portfolio should also be diversified further by investing across different sectors and regions. The aim is to design a portfolio which at least keeps pace with inflation, whilst providing the potential for capital growth over the longer term. Putting this into context, this graph shows how our growth portfolios have performed since January 19, since the end of September this year. So the blue line illustrates our growth portfolio, which is suitable for John, and that's achieved an average annual return of 9.5%. The green line illustrates our sustainable portfolio, which is more suitable for Fiona, and that's got an average return of 14%. Inflation over this same period of time averaged 2.7%. So we're pleased that our portfolios have delivered what they're designed to do. Investing is about risk and reward. These returns are difficult to find without taking some investment risk, and the value of your portfolio will fluctuate, as you can see back in March this year when COVID-19 struck. Remember that investments are to be held for the longer term. They are not a short-term solution. So since then, our portfolios have recovered well. So you saved and saved and saved into your pension and invested it in line with your view of risk. But what is this actually going to give you when you come to retire? There are three main ways to use pensions in retirement. You may have a final salary pension scheme, which guarantees to pay you a pension based on your salary and service years relative to that particular employment. Flexi access drawdown, so this is where you can draw down as much as you like, when you like, but you could deplete the value of your fund if you draw down too much. You may prefer an annuity purchase, so this is where you give the insurance company the capital value of your pension, and then they promise to pay you an income for the rest of your life. I've covered this area off in more detail in our next webinar, the Distributing Wealth seminar, but obviously, broadly speaking, if you're looking at a retirement age of around 65, you would need, I would work on the basis, if you've got a pension value of about 1 million, you could draw down 4.5% a year, and that would give you 45,000 in terms of income. So I'm just trying to demonstrate how much you need to save into your pension funds to fund a decent level of income in retirement. It's not all about pensions. Pensions are just one savings vehicle. We like them in terms of their tax treatment, but there are also other considerations that you should think about. Can your other assets or potential inheritances help towards your plans? What are you going to spend your money on in retirement? How much do you need? How long are you going to live? This is a difficult question to answer, but it will impact on your plans. What might your pensions provide you with? So working on that 4.5% of the value figure. How much should you be paying into pensions? Again, that's a difficult question to answer, and it depends on your aspirations. We do offer advice in relation to cash flow forecasting to help you make a decision on how much to save to reach your retirement goal. A quarter of the individuals we surveyed said that they've never taken financial advice. Receiving advice can help you to stay on track. Make sure you're saving enough. Keep your beneficiaries under review. Is your investment portfolio invested correctly? Thank you. I'll now pass you over to Sarah.
Okay, lovely. Thank you very much for those insights, Kim. And don't forget, if you've got any questions for Kim or the financial planning team, You can ask those in the question box on the right of your screen. So next up is me. I'm going to be talking to you about some of the legal steps that you can take in order to plan for your future. I'd like to thank you all once again for attending these webinars. They come off the back of our Planning for the Future report, a report which sets out the results of a survey in which over 1,000 people were asked for their views on investments, tax and future planning. If you haven't downloaded the report yet, then please get in contact, go to our website and we can provide you with a copy. It really does make for an interesting read, and it captures a snapshot of people's views in these unprecedented times. To introduce myself, I'm a solicitor and I'm Director of Legal Services at Kreston Reeves. I've been in practice for over 15 years, working with private clients, dealing with wills, probate and trusts. I'm very pleased today to be talking alongside my colleagues. I came to work in-house at Kreston Reeves because I'm passionate about providing a holistic approach for clients and working alongside our financial planning advisors, tax team and other professionals to give clients the solutions they need. As I said earlier, in this webinar, I'm going to be picking up on some of the legal steps that you can take to plan for your future. I'm going to be talking firstly about wills, then powers of attorney, and finally some generation skipping with deeds of variation. Ooh. Can we go back a slide? Thanks. So, looking at the results of our survey, one of the most alarming statistics reported is that 42% of those aged between 35 and 59, i.e. our accumulators, don't have a will. So in our case study, there's a strong possibility that John and Fiona may not have wills. It is common for younger people to put off doing a will, but let's look at what the consequences are for John and Fiona if they don't. The first point to make is that if they were to both pass away without leaving wills, this would cause significant uncertainty about who was to care for their children and how that future care would be paid for. Without a will and the appointment of guardians, it may require members of their family to apply to the court to be appointed as legal guardians for Josh and Amy. I'm sure I don't have to spell out to you how stressful and worrying that situation would be for everyone concerned, including the children. It's also a process that may take some time and can be quite costly as well. Next slide, please. So John and Fiona should be putting wills in place, appointing guardians for their children. Appointing guardians in your will for minor children is an essential step for any parent. It takes away that uncertainty. And the appointment of guardians as a will is perhaps not quite as simple as it might first seem. There's quite a lot of advice required around that subject. So, for example, there are rules on who can appoint guardians. In particular, unmarried fathers may need to take some advice on whether they have the right to appoint guardians. And there's also different options available for the appointment of guardians. For example, in John and Fiona's case, they might be thinking about appointing his parents, but as they're elderly, they should also consider a substitute, so perhaps Fiona's brother. The will also direct how the care and maintenance is to be funded, for example, from trust for the children, and usually that a guardian shouldn't suffer financial detriment. In the case of Fiona's brother, who's going through a divorce, you wouldn't want any monies paid to him for the benefit of the children to be pulled into those proceedings. So careful drafting, planning and consideration would be essential. Next slide, please. So what else? The majority of accumulators in our survey didn't have a will because they thought their affairs were so simple that they didn't need one. This is sometimes the result of a misconception about what happens if one spouse passes away. In this case, if John were to pass away, wouldn't it be very simple and Fiona would receive everything? Well, if he hasn't got a will, then potentially no. Next slide, please. If John passes away without a will, the intestacy rules instead will dictate how his estate is inherited. So instead of receiving everything, as many people assume, Fiona will only get John's personal belongings, a statutory legacy of 270,000 and half of his remaining estate. The other half of his estate would be inherited by his young children. Now that often comes as a huge surprise to people, and it can lead to very difficult circumstances. Thankfully, it isn't very common, but recently I dealt with a case with a young mother in her 40s who passed away leaving a spouse and 4 young children. She owned their property worth in excess of £1 million in her sole name and had an interest in the family company. And she didn't have a will. So it can happen, and it's all the more devastating when there isn't a will to offer security and clarity. Next slide, please. So what would be the implications for Fiona? Well, with house prices being what they are, it's easy to see how the application of the intestacy rules may result in Fiona not receiving all of the matrimonial home. In the case that I just mentioned, the husband now shares ownership of the matrimonial home with his children, but when they come of age, he may be forced to buy them out to keep his home. It may also mean that John's company shares may have to be split between his wife and his very young children. Again, this can cause difficulties in the running of a company and decision-making processes. The trustees acting on behalf of the children may have a very different set of duties to adhere to, usually more restrictive, and a more cautious approach is adopted by them, which can conflict with commercial decisions needed in the running of a business. If John has other shareholders, they may find those restrictions frustrating and it may hamper the running of the company. And the intestacy rules focus on what is considered to be reasonable provision for both spouse and children. They're not aimed at being tax efficient, so they won't make the best use of the reliefs from inheritance tax that may be available. Next slide, please. So there you have some very good reasons to do a will, and if you have a will, to review it. It offers financial security and clarity for your family. Gemma Spencer says in our report, it's a disservice to your family not to have a will, and she's right. It will also utilise reliefs that may save your family inheritance tax. Business property relief is an important relief which may be available on John's company shares. Dan Grange, partner and head of tax, is going to be talking around this in a bit more detail. And I'll be explaining how wills can be used to effectively plan around business property relief in my next webinar for distributors. So you might want to watch that too. Next slide, please. So why don't people make wills? Well, our survey found quite surprisingly that cost wasn't the issue. If it is an issue for you, then here at Kreston Reeves, we offer an initial meeting on a no obligation basis, where we'll review your family circumstances, your assets, inheritance tax position, and then what you want to provide for in your wills. Following that, we can give you a fee estimate, which you can decide whether to progress or not. 22% in this age bracket said they lacked time, and that's completely understandable. John's a busy business owner with lots on his plate, and his wife is caring for 2 children and holding down a job. But we now offer video calls and conferencing, so clients don't have to travel to us. And once we have had an initial meeting, we can usually deal with a lot of matters via email or post. So it's going to take a little bit of time, but it's probably more convenient perhaps than people think, or than it used to be. 23% said that they've not thought about it yet. Well, I hope this webinar has made you think about it, and if you need to, that you'll come to us for support. Next slide, please. So, what else should John and Fiona be considering? Lasting powers of attorney. These are documents in which they can appoint someone to deal with their health and welfare and property and finances if they cannot make decisions about those things for themselves. For example, if they suffer a crisis event or an emergency. Our survey, next slide. Our survey confirms that half of accumulators don't have lasting powers of attorney, and that may be because people in this age bracket assume they don't need them. A lack of capacity is something that happens further down the line and isn't relevant to them. But with John running a business, he really should be looking at putting in place LPAs as part of his crisis management and disaster planning. Who's going to run the company if John has an emergency and is unable to deal with decisions himself? Who can access the business account and pay wages and trading costs? Next slide, please. There's also a particular risk if John is a sole shareholder and director of his company. If something happens to him, either on death or a crisis event where he loses his capacity, then only shareholders have the right to appoint a new director. And as he was the only shareholder, a stalemate arises. Recent case law confirms this isn't easy to resolve and it will probably require an application to the court. So to avoid that situation, he should be looking at his will, potentially looking at amending company articles to allow an attorney to act on his behalf, and putting in place an LPA so someone can step into his shoes as a shareholder. As a branch of property and financial affairs LPAs, we can now do LPAs which just cover a business or business decisions. And that may be because it's useful to have someone different who's more familiar with the business in that role, someone like a manager in a company, perhaps not even Fiona in this case, as you might expect. Okay, next slide, please. As mentioned previously, lasting powers of attorney also cover health and welfare decisions. But why would John at such a young age need that? Well, if COVID has done anything, it's to highlight that we never know what's around the corner. So he shouldn't be leaving it to chance. Next slide, please. What other points should accumulators consider? Well, you can see from our case study that John has elderly parents. He might be anticipating receiving an inheritance from them, perhaps one that he doesn't really need. So he should be talking to his parents about skipping a generation, perhaps leaving assets to his children or grandchildren instead. His parents can make changes in their will to deal with that. And then even if they pass away, sadly, there are still post-death planning options available to redirect unwanted inheritances in a tax-efficient way. This is using a document called a deed of variation. Now, you may have heard about that in the press, and David Cameron was renowned for using one. But they're not just for prime ministers, they're available to anyone who is receiving an inheritance and doesn't want it. In the legal team, we draft them regularly when dealing with probates. So it's important that you take advice if you're due to receive an inheritance that you don't want. And we can also help with the probate process as well. Next slide, please. So, in summary, if you don't have a will, do one. And even if you do, review it regularly. Wills are documents that need to evolve and change over time to recognise your priorities and needs. They aren't something you should put in a drawer and forget about. Next slide, please. And if you're an accumulator and you have a business, well, you really should be doing a business LPA. You also need to consider doing health and welfare LPAs and ordinary property and financial affairs LPAs too. You should be talking to parents about their wills and potentially leaving unwanted inheritances to grandchildren to skip a generation and avoid tax arising every time it passes through an estate. And even after death, consider using a deed of variation to redirect unwanted inheritances. So if you're due to receive an inheritance and you don't want it, take advice, but be quick as there are some time limits. Here at Kreston Reeves, we're unique in that we can offer you comprehensive advice on all aspects of your future planning. So get in touch and take advantage of our support. Thank you very much for listening today, and I look forward to any questions later. And I'm going to hand you over now to Dan Grange, Partner and Head of Tax.
Thank you, Sarah. Good morning, everybody. As Sarah said, my name is Daniel Grange and I'm Head of Tax here at Kreston Reeves. This morning, I'm going to talk to you about the findings from our survey from our accumulators that relate to tax, and some tax planning opportunities that we think you should be thinking about. In the same way as Kim and Sarah, I will be using the case study of John and Fiona to illustrate some of our points. So in terms of the key findings from our survey, 49% of the accumulators that we surveyed own all or part of a business, which I think we were quite surprised by as being a surprisingly high proportion based on our experience and the general economy. 24% of those who are business owners do not have a succession plan in place. Given the age profile of our accumulators, this isn't surprising, but we would recommend that business owners always have an eye on the future and ensure that they're in the best possible position to react to future opportunities. If somebody comes along and makes an offer for the business that they can't turn down, or perhaps a change in circumstances. For those who do have a succession plan, a management buyout is the most anticipated result. This compares or is different from those in the distributor age group, those over 60, who expected to pass their business on to their family. And just over half of our respondents do not know their potential inheritance tax liability. Again, this is not surprising given the age profile of our accumulators. In general, we tend to find that clients sort of below their mid-50s generally are not too concerned about inheritance tax planning. But as we'll see later, and as Sarah's already talked about, there are some things that they should be thinking about. So as Sarah and Kim have explained, John in our case study is a business owner. He owns his own company. And where you're in that position, there's a great deal of flexibility about how you take your income and how you extract profit from the business. And there are a number of different ways that can be done. So a combination of salary, benefits the company provides, dividends, and as Kim has already talked about, pension contributions. When we're thinking about profit extraction, it is generally more tax efficient to take dividends than salary, particularly because of the national insurance position. But that does need to be reviewed on an individual basis. I mentioned benefits there because companies can provide certain benefits to their employees and directors that are tax-free. For example, a company can provide you with a mobile phone contract, which as long as it's in the company's name, the company pays for it all, but the employee or the director does not have a taxable benefit. So there are some tax-free benefits there to think about. And the other thing that's really important, where we've got a situation like John where he runs a company rather than a sole trader or a partnership, is that it's possible to retain profits within the company at lower rates of tax than if you extract them for your personal needs. So if they're retained in the business for funding future growth and expansion or to pay down debt within the company, that is more tax efficient than distributing the funds to John as the shareholder. When we're thinking about that profit extraction, sorry, could we go back a slide, please? When we're thinking about that profit extraction, there are some key thresholds to remember. So there's £50,000, which is the high rate threshold for income tax, and also above that level, there's a restriction on child benefit. At £100,000, your personal allowance starts getting withdrawn, and at £150,000, you start paying the additional rate of tax. And as Kim mentioned earlier, the current threshold for your pension's annual allowance being reduced is £200,000. So these different thresholds need to be borne in mind. Kim talked about company making pension contributions earlier. It's worth remembering that if you haven't used your full pension annual allowance for the previous 3 years, you can carry that forward and use it now. Where we've got a husband and wife situation, as we have here with John and Fiona, it's really important to think about the split of the shares in the company and the dividends that are paid out. to maximise the use of both of their allowances and thresholds. And as I'll come and talk about later, this can also have capital gains tax benefits on a sale of the business if the shares are owned both by John and Fiona. And this thought process doesn't apply just to business owners, it also applies to those non-business owners. So think about the split of income generating assets between husband and wife. So for example, if you've got an investment property, an investment portfolio, or interest-bearing bank accounts, think about who owns those to make sure you're getting the best out of the allowances and thresholds that are available. And also, if you're making gift aid donations, make sure it's the right person who's making those donations to get the maximum tax relief that's available. As Kim's already explained, pension contributions are incredibly tax efficient, and the pension fund is also a really tax efficient wrapper. Something that we often advise on, particularly for our business owning, own and managed business clients, is thinking about whether the pension fund can buy a property for the company to occupy. So as Kim explained, the company gets corporation tax relief on the pension contributions that are made. The company then pays rent for the use of the property to the pension fund. The company saves corporation tax on the rent that is paid, but the rent that is received by the pension fund is received tax-free. The property can grow capital gains tax-free, and it's also inheritance tax exempt as well. So a really, really efficient structure. So moving on now to inheritance tax on business assets. As we know, 49% of the accumulators who responded to our survey own all or part of a business. And there are specific inheritance tax considerations for those people. So there's a 100% exemption from inheritance tax on qualifying business assets. And those include shares in an unquoted trading company, an interest in a partnership, a trading partnership, and a sole trade business. And there's also potentially 50% relief for assets that you hold personally, but are used in a company that you control or a partnership of which you're a partner. So this is an incredibly valuable relief. Although business is in the name of the relief, you really need to think about it being a trading business. So it's not available to investment businesses, for example, property letting. If you do hold these types of assets, it's really important to think about how your wills are structured to make sure that that relief is not lost. So if you leave an exempt asset to your spouse, or so if you leave an asset to your spouse, then it's already exempt from inheritance tax. If you left BPR qualifying shares to your surviving spouse and then they sell them or the relief is later withdrawn, then that value will be subject to inheritance tax on their later death. So instead, you could think about leaving those qualifying assets to a chargeable beneficiary, for example, a trust that the spouse can benefit from, or perhaps children, depending on how old they are. I've talked there in the context of businesses. There are similar considerations for agricultural property as well, so farmland and buildings that are used for agriculture. So thinking now about what happens on a future sale of a business. So for higher rate taxpayers, the general rates are 20% for disposals of assets other than residential property, and 28% where it's a residential property that's being sold. There's something called business asset disposal relief, which most of you will know as entrepreneurs relief, and that gives a 10% rate of capital gains tax on qualifying assets. And there are conditions to be satisfied there regarding the type of asset, the length of ownership, and the nature of the business. So again, we're looking at trading and not investment assets. And there's a lifetime allowance for business asset disposal relief, which is currently £1 million per individual, which is down from the previous threshold or limit of £10 million. So in our example, John is the sole shareholder in the company. We could consider transferring shares to Fiona to mean that she can also access her business asset disposal relief allowance. And if she owns sufficient shares and holds them for more than 2 years before a sale, that could potentially result in a tax saving of £100,000. And as I mentioned earlier, it could also give some tax savings on the income that comes out of the company in the form of dividends. I'm sure you will have seen in the press that there have recently been some recommendations from the Office of Tax Simplification suggesting wide-ranging changes to capital gains tax. For what it's worth, and I don't have a sort of in-house track to Rishi Sunak, my view is that it is the wrong time in the economic cycle to be making significant changes to capital gains tax. And from your perspective, unless a sale is imminent, triggering tax now with the hope of saving tax in the future is probably not appropriate, but that really does depend on individual circumstances. Where we're talking about assets that qualify for business property relief, there is the potential to transfer those assets with the benefit of that relief before a transaction and move value to future generations more effectively than after a sale. I suppose a word of caution there, if business asset disposal relief is available in full, so the gain is taxed at 10%, you may want to secure this relief rather than look at that much longer term potential saving. Moving on to inheritance tax now, and 51% of our accumulators don't know their potential inheritance tax liability. And as I say, that's not hugely surprising. But if you don't know what your potential liability is, you don't know whether it's appropriate to take any action or not. As I said earlier, from our experience, people tend to start thinking about active inheritance tax planning from about their mid-50s onwards, although this may start earlier if circumstances allow. As Sarah's already talked about, in our case study, John has elderly parents, and thinking about generation skipping there to pass value down to Josh and Amy if John and Fiona don't want or need that money. Just something to add there, that those funds could be held in trust so that John and Fiona can control them and make sure that Josh and Amy do not use the funds inappropriately. There can also be significant income tax benefits too of the funds being available for Josh and Amy, particularly if we're thinking about paying for school or university fees and allowing us to use Josh and Amy's personal tax allowances and thresholds as well. I've put on there about lifetime gifts. As I say, most of our accumulator clients do not think about giving away assets because they're accumulating rather than distributing. But it's just worth noting there are a couple of options there, either to make outright gifts or gifts into trust. I'll be talking about that in more detail at the later seminar about distributing. It's also worth thinking about life insurance, particularly for those people who are accumulators, where they're not ready to start passing assets on. So taking out life insurance doesn't reduce the inheritance tax liability, but it does provide funds to pay that tax so that the executors and guardians don't have to sell assets to fund the tax liability. If you're married and you're going to leave all of your assets to your spouse, then effectively the inheritance tax will bite on the second death, and that's how the insurance would be structured. I think it's worth pointing out that the earlier you start and the earlier you put that in place, the lower those premiums will be, and Kim and her colleagues can advise fully on that and making sure that that life insurance is appropriate and is structured to be tax efficient. So in summary, the actions that we would recommend for our accumulators are to make sure you review the use of your tax allowances and thresholds and make sure that those are as efficient as possible. If you're a business owner, review the ownership of your business in the context of income and a future capital gain. Think about your wills, particularly in the context of assets that qualify for business property relief or agricultural property relief to secure that very valuable relief. Quantify your potential inheritance tax liability so you know whether you've got a problem or not. And if you do have a liability, consider whether life insurance would be appropriate to cover that liability and prevent the need to sell assets. I'm now going to hand back to Sarah, who is going to handle the questions, I think.
Lovely. Thank you very much for that, Dan. Yes, so that now brings us on to our Q&A section, where we have a range of panelists available to answer your questions. They all should be appearing in front of you as if by magic now. And there they all are. Thank you to everyone who's already submitted questions. If anyone hasn't, there's still a chance to do so. Questions will remain anonymous. So I'm just going to pull up the question box and look at the questions that we have. The first question I'm going to direct to Terry Bergham. Terry, are you there?
I am
you are
here.
good. Lovely. So our attendee asks, how far in advance should I be looking at doing a cash flow forecast, and how often should I review it?
Okay, so the idea of using cash flow forecasting is to understand what level of assets that you need to build up to be able to provide the right level of income and requirements. So that looks at things like pensions, savings and investments. So by understanding how much you're going to need in the future, you can put together a proper funding strategy and then review that regularly to make sure that you're on track, and also consider any changes to the assumptions used, such as investment returns and inflation, to make sure that you can make changes as and when you need to, rather than leave it too late when you've got no further time to accumulate further funds. So I review cash flow plans for my clients once a year, but it depends on your personal circumstances as to how often you should do it, but it should be done on a fairly regular basis.
Okay, lovely. Thank you for that, Terry. Okay, so our next question I'm going to direct to Joe White. Are you ready, Joe?
Yep.
Our attendee asks, I've heard that holding large cash balances in a company can prejudice both the capital gains tax and inheritance tax reliefs mentioned. Is this the case?
Potentially, yes. The issue is around there's two tests. One's capital gains tax, which talks about the business having to be more than 80% trading, which looks at turnover, people's time, profit, and also capital employed. So if you retain a significant amount of cash in the business and that cash balance builds up over time, that could start to sway the split. However, if the money is purely from retained profit, or it's earmarked for a particular purpose to continue the business, then that shouldn't prejudice the claim. If you do actively invest it in other things, however, for example, stocks and shares, that will have potentially a more significant impact on the availability of what was known as entrepreneurs relief. For inheritance tax purposes, we have to look at a 50-50 test, but you are looking at the same sort of test, so assets employed, time spent, turnover, etc., and the same rules apply. So it's the same concept across both taxes, but the thresholds are slightly different.
Okay, that's lovely. Thank you for that, Joe. That's Joe White, tax to there. Next question to Phil Lansbury, head of legal. Who can be a guardian, and do they need to consent to the appointment? Phil? Oh, I think Phil is on mute.
Hi, this is a good follow-up from what you were saying earlier, Sarah, about people appointing guardians. So it's a pretty straightforward business, really. Anyone can be appointed a guardian as long as they're over 18. So that's the legal position. There are practical considerations, though. Obviously, you're looking at someone who's going to be having responsibility for children until they're 18. From that point onwards, legally, guardians have no powers over the children, much as you might like them to go on for a bit longer. They can't technically do that. So they've got to have enough shelf life and the energy to be able to look after these children, and that can be quite a task for people of a certain age. So be mindful of the generations you're thinking of using. But there's no legal restriction on it, and you don't need their consent. But it would be foolhardy to die with the will appointing people only to be phoned up to say that this doesn't suit them at the moment and they wouldn't be able to help. So the last thing you want is a negative response in a crisis situation. So for heaven's sake, make sure you tell them and explain what you want. So you may want them to go to church every Sunday. You may not want them to go to church every Sunday. You might want them to be educated privately. That might be the last thing on your mind. There are all sorts of things you might want to discuss with them. So make sure you have those discussions to see that they know what they're taking on and what your wishes are.
Okay, thanks, Phil. That's great advice. I have another question here, which I'll direct at Lee Hayward, who's in our financial planning team. Lee, someone has asked, what can people do to help out their parents when planning for care home fees?
Yeah, thank you very much, Sarah. That's an interesting one. I think the first point to start with on that is going to be looking at making sure things like wills and powers of attorney are in place. Can be a difficult conversation perhaps to bring up with your parents, but I think in this context, obviously, it's well worth doing. So I think that's the start point. Strangely, it might seem there aren't specific planning products in place for long-term care. So really, it's a case of looking to build wealth over time that you can then use later on to fund care. But if we're talking about parents that are already, let's say, elderly, and they may be going into care, then it comes down really, I think, to helping them, or perhaps if the parents are too elderly to get involved themselves, is to actually on their behalf make inquiries with the likes of financial advisors or solar accredited financial advisors to see what's available, because the first port of call really is to look at whether they're going to get any assistance from the local authority, which is not very often the case, to be perfectly honest. If you've got assets in excess of £23,250, you're not going to get any help from the local authority. So beyond that, there is something called NHS continuing healthcare, which may be applicable to people who have primarily a nursing care requirement or a medical condition that's particularly the reason for them having to go into care. An NHS continuing healthcare can be extremely useful if you qualify. There's strict qualification criteria, but it will pay for everything if you are, including residential care costs, if you qualify. Beyond that, it starts really for us to start looking at the self-funders, those people that have got capital or income that they're going to be able to use themselves. And that could be, it might involve sale of the property. It might involve using capital from cash positions to try and fund care, but obviously with interest rates where they are, that capital is going to erode very quickly if it's sitting in cash. So alternative investments that we can look at, taking into account the client's risk profile and so on. But also there is a product specifically at the point of care needs called an immediate care needs annuity. And that is something that isn't well publicized. I don't think lots of people I speak to have never heard of it, but it is an annuity product. It's designed to provide guaranteed income for the life of the recipient. It's bought with a lump sum, so if there is capital available, it's possible for you to buy one of these things. And these aren't like pension annuities in the sense that we looked earlier on. I think Kim showed a slide where you need £1 million to give you a 4.5% return. These are underwritten annuities. In my experience, we're talking about typical annuity rates of between maybe 15 and 25%. So they're taking obviously the life expectancy of an elderly individual into account, so that the rates are significantly higher. So if you've got £100,000, you can guarantee £20,000 worth of income, just as a ballpark figure. For life, tax-free, paid to the care home, typically directly, that can be a very useful way of bridging a shortfall in income between care costs and pension income and other income that the individuals might have. So that's the product that is well worth, talking to somebody about at the appropriate time.
Okay, thank you, Lee. The next question is a new question that's just come in, which I'm going to direct to Joe. Joe, who's our tax director here at Kreston Reeves. So Paul says, I'm looking to change my tax domicile from the UK. What assets can I keep in the UK? How will those assets left in the UK and any associated income from those assets be treated for income tax, capital gains tax, inheritance tax? How many years in the UK before I revert back to UK tax domicile? It's quite a long question. Perhaps not one you fully answer today, Joe.
No, absolutely, and there's quite a lot of complexities in there depending on what country you move away to, etc. The issue around domicile affects your inheritance tax liability, and generally speaking, UK assets such as property or stocks and shares listed here, etc., will be caught within that net. Income tax, slightly different rules, and capital gains tax, again, slightly different rules. But if you are looking at certainly property assets such as commercial or residential, you can't really get out of UK tax if the property is situated here. Certainly something that we can pick up and advise you on, but I think we need to understand a bit more detail as to what your expectations are in terms of moving it forward, etc., before we can fully answer that question.
Okay, so get in contact with Joe or Dan on that, Paul. Next question, I'm going to combine two questions here, which we've received on deeds of variation, Phil, and direct them to you. Firstly, what are the time limits on a deed of variation, and can you redirect just part of your inheritance?
First question first, time limits. Curiously, there's no time limit for when you can do a deed of variation.
Oh, we appear to have lost Phil there. So I'll briefly answer that. What Phil was about to say is there's no time limit on doing a deed of variation, but there is a time limit if you wish it to be effective for inheritance tax purposes. The idea behind a variation is that you redirect your inheritance, and then instead of the asset passing into your estate and back out again, to which the 7-year rule would apply for inheritance tax, it effectively leapfrogs you and goes directly to the person to whom you're redirecting to. So for inheritance tax purposes, if you want that to be the outcome, then you need to complete the variation within 2 years of the person's death. And yes, it is absolutely possible to redirect just part of your inheritance if that is what you want to do. Okay, I think we may have time for one more question. So let me just have a look at our list. Kim, if I can direct this to you. I have low, medium and high growth rate assumption, have low, medium and high growth rate assumptions on portfolios changed in recent years? If so, what do you think are reasonable percentages important when considering how your pension pot would grow?
Sarah, so the answer to that is yes, and the actual the actual date as when the FCA changed it. I can't remember now. It was a few years ago. But they used to, the providers used to have illustrations based on certain growth rates, and they have actually come down. We always work on the basis that if you're a cautious investor, 3% is comfortable. If you're a balanced investor, 5% is comfortable. But that is over a period of time. Like I said in my presentation, investing isn't a short-term solution. So you're not going to make 5% in a year. It's an annual average. And like I say, if you're cautious, 3% should be comfortable, 5% for balanced, 7% for growth or higher risk. Obviously, it's about risk and return. So, yeah.
Okay. Thanks for that, Kim. Right, so I'm conscious of the time and other commitments that people may have, so thank you very much for listening today. Any questions that we didn't get time for, we will respond to you directly using your contact details provided. You are, of course, welcome to contact us. I think probably that's it for today. So thank you very much for attending. If you haven't seen our report, Planning for the Future, let us know. We can provide you with a copy, and you'll shortly be receiving a message asking for feedback, and we'd be grateful if you could complete that. We hope you found the webinar useful, and please do contact us if you would like any more help. Bye.